What is the order of abatement? Have you ever wondered what happens when an estate does not have enough assets to cover all the gifts promised in a will? This situation leads us to the concept of abatement. Abatement refers to the process of reducing or eliminating bequests when an estate's available assets are insufficient to satisfy all debts, expenses, and legacies fully. Understanding the order of abatement is essential for anyone involved in estate planning or the probate process. The order of abatement is the legal sequence that determines how different types of gifts are reduced to meet the estate's obligations. When an estate must pay debts, taxes, and administrative costs, but the total value of the estate falls short, the order of abatement kicks in. First, if the will does not specify an abatement order, the state's laws will apply. The basic principle is that abatement occurs only when the estate cannot fully cover all bequests after paying debts and expenses. The goal is to preserve the testator's intent while fairly reducing gifts. Now, let's break down the typical order of abatement. The first category to be used is property not disposed of by the will, also known as intestate property. This includes any part of the estate not specifically mentioned in the will. Next in line are residuary bequests. The residuary estate consists of what remains after all specific and general legacies have been paid. These gifts are next to be abated. Following that are general legacies. These are gifts of a general nature, often monetary amounts not tied to specific property. General legacies are reduced proportionally, meaning each beneficiary's gift is cut back based on the total shortfall. Then we have demonstrative legacies, which are specific sums of money to be paid from a particular source or fund. These also abate on a proportional basis. Next come specific bequests of personal property, such as jewelry or cars. These gifts are abated after general and demonstrative legacies, again in proportion to the shortfall. Lastly, specific bequests of real property, like land and buildings, are abated. This typically happens last since real property is often less liquid and more challenging to divide or sell quickly. It is important to note that in many jurisdictions, there is no distinction between real and personal property in the abatement order. The same sequence applies to both types. Executors must manage abatement carefully to respect the testator's intent and comply with state laws. If the will includes clear abatement instructions, those take precedence over statutory rules. Abatement differs from insolvency. In abatement, the estate is solvent but lacks sufficient liquid assets to pay all legacies in full immediately. From an estate planning perspective, it is wise for testators to include clear abatement instructions in their wills. This allows for more control over which gifts are reduced first and can help protect important bequests, especially family heirlooms. Executors should also be aware of the order of abatement to manage estate distributions properly. They need to communicate with beneficiaries about possible reductions in their inheritances due to estate debts or expenses. Understanding the order of abatement is essential for honoring the testator's wishes while ensuring that debts and expenses are paid.